Good morning. This is Jen, the Liberty Lion. Today I want to talk to you about the fiction, and I want to give you a couple quotes and some books I've read, and I will post the links to the book in the description. If the links do not appear as soon as the video is posted, then I will post the links soon after the video is posted. So we have a couple books, The Law of Evidence and Presumption in the Law. And I have a couple quotes from these books. But I want to make the point that it's all reference to the fiction. The entire system, the entire legal system is built on a fiction. It's like the little boy in The Matrix who gives Neo the spoon and says, don't try to bend the spoon, just realize that there really isn't a spoon. So there really isn't a legal system because it's all built up on fiction. Okay, when you realize there is no spoon, then it's easily bent. A system of laws based on natural law, moral good character, etc., would absolutely end the legal system as we know it. It could not survive. The legal system cannot survive without the fictions. And by fictions, we mean rhetoric, persuasion, influencing the minds of the juries, which is what an attorney would do, a drill attorney would do. They use fraud, they use lies, they deceive people, they deceive the jury, they deceive in the papers that they write, they use deceptions. They interpret the acts of the legislation's wrongs. Well, so this is either state or federal legislative acts. They're written vaguely to deceive people and so that they can be interpreted. The agencies, departments, bureaus, etc. are allowed to interpret the acts, and the courts will always side with the agency's interpretation. And you can read more about this in an article called Statutes with Multiple Personality Disorders. It talks about this issue where the judge will just allow anyone inside government to interpret what the law means, and the laws are written vaguely, and the Congress or legislators of the state know that their laws are not going to be, the intention is not going to take effect, but it's the interpretation that the court is going to side with, which basically means that the law can mean anything that the departments and agencies decide that it means, or any instrumentality. So if the instrumentality wants to interpret the law, they can. And this is wrong, and it's immoral, and it will ever expand the legal system into oblivion. Okay, so if the courts realized or stopped using the fictions, rhetoric, persuasion, influence, fraud, lies, deceit, interpretations of vague legislations, they would no longer be able to win. Okay, the attorneys would no longer be able to win cases for governments. Okay, so the person with the better fiction, the better story, when he's in a case against a juror, or a case to convince a jury of something, the one with the better fiction will win. Okay, so this is why some people have said we need to demand the courts and government have good morals. And then they claim that electing better people will solve this problem. Of course, we know that the elections are all taken over by various corporations and other governments and stuff. We saw that during the Trump and Biden election runoff. Morals in courts is like a dead metaphor. It is something of the past, if it ever even did exist at all. Okay? So only one thing can be proven. This is a treatise of the law of evidence. by, this is Isaac Redfield. And this book was written, I believe, in the late 1800s. This is volume 1. Okay, so this is Simon Greenfield and Isaac Redfield, or Greenleaf. Simon Greenleaf and Isaac Redfield, a treatise on the law of evidence. And he says in here that there's only one thing that can be proven, one thing that can absolutely be proven, and that's mathematical equations. So he says, none but mathematical truth is susceptible of that high degree of evidence called demonstration, which excludes all possibility of error, and which therefore may reasonably be required in support of every mathematical deduction. So I've been reading a lot about how to find fictions, how to see the fiction, and it's something that you kind of have to understand to really get a good grasp on, learning that basically everything in the legal system is fiction. It's rhetoric, it's persuasion, and it's meant to move you into action, to act in the way that they want you to act. So presumptions in the law, a suggestion. Now, I'm not saying that all fictions are bad. Some fictions are good. It just allows us to act on the stage of life, stage of community or society in a way where we can all get along. So this presumptions in the law has some interesting things to say, and I'm just going to read from it, and you can find this book on archive.org. Presumption hominid is not the same as presumptio fact. Homo does not mean factum. The trouble is we do not translate presumptio juris and presumption hominid correctly. The Latin genitive in these two expressions may be translated with either of the English prepositions of or by, but the more correct one is by and not of. The exact English equivalents are presumption by law and presumption by man. Every presumption, whether juris or hominid, is a presumption of fact, in the sense that an inference of fact is involved in it, an inference. Okay, so like a suggestion, a type of persuasion, presumption. Okay, so inference. That is true as far as the law relating to evidence and proof is concerned, and to that law we are confining ourselves here. By every presumption in that law, a fact is, by inference, deemed proved. So think about that. They're saying that by presumption, a fact is proved. Presumptio juris means a presumption or inference of fact made by law. Presumption hominid means a presumption, inference of fact made by man. It happens that who the man is makes no difference. He may be embodied in the form of a judge, as distinct from the court. So this means a judge does not move the court, or you don't go to court for a judge's opinion. You go to court for a court's opinion. So the court and the judge or the justice is different. Or in the form of a jury. Because a presumption of fact made by man is nothing but the result of an inference made by human reasoning, which is logic. There is therefore nothing unusual about it that requires any differentiation of its use in the law from its use from another connection. But when we come to a presumption of fact made by law, we have a different problem, because it is not necessarily the result of logical inference. Okay? So, but when we come to a presumption of fact made by law, we have a different problem, because it is not necessarily the result of logic. So laws are not necessarily logical. They're not necessarily reasonable. They're not necessarily something written that makes sense or common sense. Indeed, the result is sometimes most illogical and sometimes absolutely false when compared with real truth. So the law is sometimes illogical and false. It is sometimes the result of logical reasoning, sometimes it is not. It is always the result of what is called legal reasoning, fictional reasoning, which has its basis not logical in truth, but in expediency. So law is meant to be expedient. This expediency rests upon many supports, among them expedition of trials, saving time and expense, and is itself the support or one of the supports of a superstructure called administration of justice. Okay, so laws are not always logical. They're not always truth. They're not always reasonable. They're made to be expedient, to save time. They're based on presumptions or inferences, fictions, rhetoric, persuasion, influence, fraud, lies, deceit, sometimes just downright lies. So in other words, there is no law. There is no truth. There is no spoon. There is no morals. And if they used morals in the law, they would have to look at law like a mathematical equation, and we would find that there is no law because it's all based on fictions, falsities, illogical things, lies, deceit, inferences, presumptions. Now that, again, is not to say that it's totally and completely fiction, but for the most part, most of it is fiction. And we learned in a previous video that I did that vagueness in the law allows for attorneys and judges and lawyers and courts in general, judges, to interpret the law in whatever way they want so that they can win their cases. So like, share, and subscribe, and you'll be hearing more of this information, of this type of information on fictions, and possibly some information on serving the court's notices so that you can get around the fiction to truth.